Hello, my name is Dan Blinn. I'm the managing attorney at Consumer Law Group. One of the things that consumers call us about very frequently is a problem with car dealerships where they think they're all set, they signed a contract and they're told they're all set. And then the dealership calls them up and says there's a problem, you need to bring the car back. We call those yo-yo transactions. Think about a yo-yo where the yo-yo goes down and then you pull the string and then they try to bring it back, and that's what car dealers sometimes try to do. If you look at your contract, a retail installment contract, you'll see that it's a contract between the car dealership and the consumer, where the car dealer is listed as the creditor and the seller in the transaction. The problem is the car dealers don't look at it that way because they're not really equipped to service these loans. They like to get cash for these transactions, so they plan to sell these contracts to third-party banks or finance companies. When there's a problem between the dealership and the bank or finance company, and they refuse to go through with that assignment, then the dealership is stuck with the paper, and they don't want that. So they call the consumer and they tell them they have to bring the car back, or perhaps they have to sign a new contract. Now, that is not consistent with the consumer's rights, because the consumer does have the ability and the right to enforce these contracts. Now, if a consumer finds themselves in a situation where a dealer is telling them that there's a problem with the financing, there are several things that we suggest that they do. First, we suggest that you try to make all communications written communications, either by email or text message. Frequently, a car dealer is going to deny what was said during these transactions, but if these communications are in writing, you'll have proof. The second thing that you should do is get your paperwork out of the glove compartment. That contract is going to be the only proof that you had a binding and enforceable contract to keep that car. So you want to make sure that if the dealership takes that car, and unfortunately sometimes dealerships will repossess these cars, you want to make sure that you still have your evidence. We also suggest that you ask the dealership, can I just make my payment to you? Our contract says that you're this creditor under the contract, so how about if I make payments to you? Now, the dealership isn't going to want to do this, and they're probably going to refuse. And again, it's best if you get that refusal in writing. Now, sometimes under these circumstances, a dealership is going to tell a consumer that they have to get a different car or they have to sign a new contract. If the dealership is doing that, we recommend that people ask the dealer whether you have the option to simply get your deposit back, and whether, if you had a trade-in, you can get your trade-in back as well. And again, it's best if these communications are in writing so you have proof. If a dealer does want you to sign a new contract, ask them to send you a copy in advance so you can take a look at it. And we suggest that you have an attorney look over any new contract and advise you before you proceed with anything. Any more questions? Feel free to call us or go to www.consumerlawgroup.com.